Joining me in the studio to take a look at them is a foremost students' union leader when he was a student. He's now a public interest lawyer, actually the President Public Interest Lawyers League, Abdul Mahmood. Thank you so much for joining me.
Thanks, Amici, for having me. It's my pleasure being here again.
Thank you so much. Now, what do you think is the basis on which, of course, that judgment came in favor of Andrew Chendo of the APC? Of course, you followed, I presume you followed the activities of the tribunal.
I did. The elections in Rivers last year, particularly from 2015 through last year, provided opportunity for those of us who are interested in the health and architecture of electoral reforms in the country, that opportunity of looking at some of the issues that we have argued over the years for. And it also afforded us the opportunity of scrutinizing the performance of INEC and also scrutinizing politicians who had returned back to the country to seek the mandate, the mandate of the people. Yes, I followed the events in Rivers in 2015 up to the point in which the elections were nullified and every other politician was asked to go back and face the country in Rivers. I've gone through the judgment. I'm shocked by what I've seen and what I've read, and I'm particularly worried about the language in which the judgment is couched. It doesn't sound or look legal to me. But more importantly, the attempt by statutory institutions or platforms like election tribunals seeking to whittle down, the statutory powers of INEC are some of the things that are worrying in this judgment.
Of course, the issue of the role of INEC featured prominently, the role of INEC in cancelling some results in some local governments.
Absolutely.
Came up.
Absolutely. If you look at Section 53 of the Electoral Act, where issue of overvoting comes into play, it is within the statutory powers of INEC, to nullify or cancel whatever result that emerges from an election where the votes that were cast, were more than the PVC distributed, or the number of registered voters in that particular constituency or ward or polling unit, as the case may be. The contentious local government going through the judgment here are basically Emoa local government area of Rivers State and Ikwere local government of Rivers State. And for some of us that followed the event in 2016, these were actually troubled local government areas where fantastic results were posted by political parties who claim to have more popularity on the ground in some of these local government. But in the wisdom of INEC had to do what it was statutorily empowered to do, outrightly cancel the election. But here the trick is this: if the figures at play cannot substantially affect the total result already declared by INEC is not obligated or mandated by the Act, to call for further elections in those problematic local government areas. I think that is where the problem is here. But more importantly, I made a point about whittling down the powers of INEC.
Before you get to that, what the tribunal said in its judgment is that INEC promised that the results of the first election held earlier in 2016, which were collated, would be included in the final result, and that it was not included. Does it mean that INEC cancelled that election, those results from those constituencies, or it failed to include them?
Well, the result we are talking about here is not a result of the whole local government area. It's a result of certain PUs and wards. Some of these wards results were cancelled. Some of these PU results were cancelled on the basis of the fact that I've already adduced overvoting and all that. The results that were shown not matching the amount of PVC or number of registered voters in that locality in Rivers State. It was within the powers of INEC to nullify and cancel the result outrightly. If it was the promise INEC. I've not read it anywhere that INEC made that promise, and even argued that position at the position of the tribunal. But it's a strange aspect of the judgment. I have read it, I have seen it, and there's nowhere in the pleadings of INEC that relate to that point that the tribunal makes.
Let me quote from the judgment from the tribunal. We hold that the first respondents unlawfully excluded, that's INEC. The results of the Ikwere local government area, Emohua local government area, Krika Ward 6, Port Harcourt Ward 4, and Port Harcourt Ward 10 in the said election. This was what the tribunal relied on.
Yeah,
INEC shouldn't have excluded those.
The argument of INEC is this: at the point of not becoming the INEC attorney, because I don't have interest in this matter. If you look at section 53 of the electoral, it said that no voter shall vote for more than one candidate or record more than one vote in favor of any candidate at any election. Subsection 2 of 53 says, where the vote cast at an election, any polling unit exceed the number of registered voters in that polling unit, the result of the election for that polling unit shall be declared null and void by the commission, and another election may be conducted at a date to be fixed by the commission where the result of the polling unit may affect the overall result in the constituency. It's strange that the tribunal used the word unlawful, because if we make recourse to the Electoral Act, which of course is a law, it gives INEC the power to declare result null and void.
Maybe the tribunal is not comfortable with the process that INEC employed.
Well, it's a different ball game. But in the context of the power of INEC exercises power consistent with the provisions of the Electoral Act itself. But the problem here is this: in INEC's wisdom and judgment, the results that were nullified, according to some of the arguments I've read that INEC have pushed, does not in any way, affect the overall result of the constituency. So if INEC had gone, of course they did nullify the result. If they had gone to organize a rerun election, whatever outcome of that rerun election will not have affected the result already declared by INEC. That's the INEC position. It is for the Court of Appeal to clear this legal issue.
So what you're saying is that once INEC nullifies any results, it remains lawful, and not even judgments from the court can set them aside.
INEC cannot wake up and nullify an election for the purposes of nullification. But where INEC establishes the fact that there were disturbances, there were violence, and more particularly overvoting in that election, the law grants INEC the power to nullify and void the election. Of course, under Section 6 of the Constitution, the court, including tribunal created pursuant to the Constitution, also has the powers to inquire into the grounds in which INEC has adduced for nullifying or voiding the election. But if you read the judgment of the tribunal does not establish ground upon which he reached the conclusion.
What the tribunal said was that there was this promise from INEC after the first inconclusive election that after the results were collated, they will form part of the final result. But it never did. Well, according to the tribunal,
I've gone through the judgment. There's nothing in inference that refers to the fact that INEC made certain promise on a certain day, or even document certificate to show that INEC made such promise. But we can take the judgment of, we can take the opinion of His Learned Justice for its word. But if you go to the pleadings of INEC, and I have the opportunity of looking at it, this strange aspect of the judgment was not even raised in the pleadings of INEC. So I found the judgment, that aspect of the judgment, very strange.
The tribunal relied on the documents tendered by the police in reaching its judgment, saying that it should be at par with that of INEC. It even described INEC as an interested party, so it has to rely more on documents, results of the evidence supplied by the police. So what does that mean?
What it basically means here, and this is the effect of the judgment. If you look at Section 153 of the Constitution, which grants which creates INEC, grants it the power to conduct elections. There is no other agency or institution of government that has that power to conduct elections or hold referendum in our country. INEC has that power. If you look at Section 1 of the Electoral Act, INEC has the same power to conduct elections and all the ancillary powers granted to it by the Constitution and by the Electoral Act. Documentary piece of documents produced by INEC, if you look at Section 63 of the Electoral Act, it says that election results or all the documents relating to elections are in the custody of INEC, but INEC has the power, it's mandated to deliver duplicate copies of these documents to party polling agents and to the police. I think Section 3 of Section 1 of the Electoral Act specifically mentions the police. But the problematic here, and that's where we're going to case law, going to procedure, the duplicate copies that are with the police and the polling agents, are they original copies of the document in custody of INEC? They are not. We can call in aid Section 72 of the Electoral Act, which says that all official documents pertaining to elections should be in the custody of INEC. But there's also a catch under Section 77. Section 7 gives, people whose interests will be affected by the outcome of any elections, the right of access to these documents. On the basis of that, if you have a petition before a competent tribunal in our country, you can proceed to INEC. Ask INEC on the basis of Section 77, please produce certified true copy of the original documents that I'm inquiring for that is in your possession. And I haven't paid the prescribed fee. Now we go to Section 104 of the Evidence Act. The law says once you're asking for a city's copy of a document, you must pay the prescribed fee. But in this particular case, police had duplicate copies or the pink copy of the election result in some of these contestable local government areas we are referring to. When the matter came out, the petitioner, from the judgment I've read, called a DSP, I think was Petitioner's Witness 5, who didn't present the duplicate copy of the election result that was already in the possession of the police. What he presented was a photocopy or photocopies.
Duplicates. Certified duplicate.
Photocopies of the duplicate,
but
certified by the police. By the police, which is against the law. One, the document or documents in question are in custody of the originals of the document in question are in custody of INEC. Two, the documents in question, INEC is the maker of the document, not police. By law, the police or the petitioner ought to have approached INEC to produce the documents in his possession, in his custody. Having paid prescribed fee with the CTC stamp sealed on the face of the document, present it and tender it before the tribunal and lead evidence on the basis of the documents that have been tendered. In this case, nothing was done. And there's a strange aspect of the judgment. I'm sure you have read it. Page 13 or 14 and 14 of the judgment, where arguments were made about the admissibility of or inadmissibility of these documents. They are big legal jargons. What it simply means is this: are these documents tenderable before the tribunal? Can I place it before the tribunal and the tribunal will admit it or accept it?
And the tribunal ruled in the affirmative. Based on their judgment, let me take a quote here.
Yeah.
We did hold that in that matter that such document is admissible. That is the police certified copy.
Yeah.
This is because the police is statutorily entitled to receive the duplicate copy of the election result under Section 63, subsection 3 of the Electoral Act 2010 as amended. The copy received by the police is always a duplicate original which remains in their custody. Such document with the police is a document within the public domain and which can be accessed by members of the public as the need arises.
It is beyond contest that the duplicate copies of the original election results were in the police custody, because by virtue of Section 3, Section 2, INEC gave party polling agents and police copies of the result. Call them the pink copies. The law here is very clear. Section 104 of the Evidence Act, that when you are not the maker of a document, you are not the maker of the document, but the document in duplicate copy is in your custody, what you ought to do is tender before the court the duplicate copy of the document in your possession. The police did not tender the duplicate copy of the original result in his possession. What he tendered were photocopies of the duplicate copies, certified by the police.
The court said what the police received is always a duplicate original.
The duplicate original, it's just common sense here. What is a duplicate? Duplicate is a similitude, a replica of an original. So to say that duplicate original, it does not.
So the original was not with the police, but they only had a copies that given to them. The original remains with INEC.
The original remains with the INEC. So what the petitioner ought to have done was proceed to INEC under Section 77, because he has right of access. That please, INEC, I'm relying on this document in the petition before the tribunal. Please, can you release the certified true copy of this document to me? This is the amount I'm paying based on the assessment, fee assessment you have made. Nothing of such was done. The court relied, I followed the...
Maybe he didn't trust INEC as an interested party now based on the conclusion of the
as an interested party.
tribunal.
And that is where it becomes very intriguing. Because if the tribunal had adversed its mind to case laws, ranging from Gambari against INEC, Goodwill Trust Investment Limited, and Wheat and Bush, there are a line of cases where the Superior Appellate Court in our country, Court of Appeal, and the Supreme Court have consistently held that where the original documents is in custody of a state institution, citizens are advised to approach that institution to produce the CTC copy.
Okay, we'll dwell more on that, but we take a short break now. When we come back, more issues arising from the Rivers East senatorial election. The judgment from the tribunal came some few weeks ago, and Abdul Mahmoud, public interest lawyer, has more to say. Please don't go far away.
We see community action for good governance. They see poverty and want. We see perseverance and the will to go on. They see economic law. We see the ingenuity and creative spirit of our people. We are AIT News, fresh, authentic views of Africa. How would you rather see the world? AIT News, all sides, all the time.
Issues are rising from the judgment given by an election tribunal in the Rivers State East Senatorial District election petition that was before it. Abdul Mahmoud is a public interest lawyer, and he was making some points, citing cases about documents to be tendered during election petition cases. You made reference to the fact that it must be from state institutions. The police is also a state institution.
The police is a state institution, but in respect of electoral matters, our law does not confer that power on that power of production, that power.
Was the electoral as specific that it should come from INEC?
The Electoral Act, I think it's important we make recourse to it for those. By virtue of Section 77, by virtue of Section 72, it says the chief electoral commissioner or any officer authorized by him shall keep official custody of all the documents, including statement of result and ballot papers relating to the election, which are returned to the commission
or any other officer.
Or any other officer authorized by him. Or any other officer authorized by him. If you go to Section 77, it says, Section 771, the resident electoral commission in a state where an election is conducted shall within 7 days after an application is made to him by any of the parties to an election petition cause such document of the certified true copy to be issued to the said party. Subsection 2 is criminalizes the willfulness of INEC refusing to grant access to this document. But then we also have body of laws. If we make recourse to evidence law, evidential laws that guide the way matters are presented, procedures in our court, it tells us the procedure for tendering documents of this nature, particularly Section 104, Section 36, Section 37. They are public documents in the custody of a public institution. The original copy, not duplicate copy. But our superior courts have held that when you are presenting, election result, the original copy in the possession or custody of INEC is always preferable, to be tendered. But those copies must be CTC, truly certified copies of the original. What the police did here, and that's why I find it very strange, the judgment of the judgment of the tribunal. And I want to go back a little. If you read the judgment, reference was made to Nnamdi Ezike's case, by the lawyers to the respondents, and also by the court. The Nnamdi Ezike's case is simple. When the matter came up before the Court of Appeal, I think in 2011, it was an election matter in the tribunal where police tendered duplicate copies of election results. The tribunal wrongly refused to accept the document, holding that duplicate copies ought to have been certified by INEC. It went upstairs, up to the Court of Appeal. It was there the Court of Appeal clarified the law that the tribunal wrongly rejected a piece of evidence that he ought to have admitted. Now there's a distinction between Nnamdi's case and Andrew Chendu's case,
and
before
Sekibo.
and Sekibo's case in the tribunal in Port Harcourt. The distinction is this: the petitioner here sought to present a piece of vital document that was not in its duplicate state. That's the distinction. What they presented was they got the duplicate copy given to police by INEC. What the police did was photocopy it, certified it itself. The law does not allow the police to certify its own document because it's not the maker of that document. The maker of the document is INEC. It's only INEC that can certify its own document. And on the basis of that, it's only INEC that can be questioned on the basis of the veracity of the authenticity of his document. That's the distinction. And that's why I think the tribunal got it wrong. And that's why I think the public interest matter of this case becomes sharp and acute. What the tribunal sought to do here was to whittle the powers of INEC. And the effect
and describe INEC as an interested party. So what does the law say about INEC? Because INEC was joining this case. INEC, to some extent, is an interested party because in that case, INEC, based on the fact, that's a layman's contraction.
No, INEC.
Now, because the position INEC took was contrary to that of Uche.
Yeah. INEC is an impartial arbiter. It's been charged constitutionally, statutorily to conduct elections. INEC conducted the 19th March election and 10 December 2016 elections respectively.
So it cannot be seen to be an interested party.
So INEC's responsibility and legal duty is to defend the results that it said represent the genuine electoral aspiration of the voters in Rivers State East Senatorial District. So INEC cannot.
So INEC just defended the result it declared.
The result is declared. When you say somebody is an interested party, what it means is that something of interest, something of pecuniary, something physical, will be accruable to that party. There's nothing accruable in the Rivers State Senatorial elections to INEC. What? INEC is an impartial arbiter. I think what the tribunal did there was to use a superfluous language to clothe, an institution of state.
Is it the first time a court has described INEC as an interested party in an election?
Well, to my knowledge, this is the first time I'm reading it.
What's the implication for future election cases? Many of them, of course, will come arising from
this is the implication here. We all followed what happened in Rivers in 2015 and 2016. The security institutions in our country were implicated in shenanigans that took place in that state in 2016.
Implicated by who?
By series of reports released by human rights group, election monitors in our country. So for the tribunal to hold that the police have powers to produce his own document, certify his own document, tender it before a tribunal, and the tender become legal and admissible, opens a dangerous door for the conduct of elections in our country tomorrow. Nigerian politicians, for what they are, will not be looking at the gains they can make by approaching the people in the street, asking them to vote for them. They'll be looking for ways they can cajole, they can bribe, they can bring the police association, on their side, just for the sole purpose of securing that advantage that the tribunal has opened. That, look, you don't need the certification of document of INEC. When the police produce it before the tribunal, who accept it and it's admissible in law. I think that's a dangerous specter for the health of electoral reform and for our constitutional democracy. We should be working towards a situation in the progress of election in our country where security agencies will have little or no role to perform. It is the responsibility of INEC, as it is done elsewhere. We should be working towards a process that will allow politicians to secure victory at the ballot rather than seeking pirate victories,
the tribunal described the INEC as an interested party. Yeah. Would you say the police is a neutral party when it comes to conduct of election and tendering of documents before tribunals and courts?
By virtue of Section 4 of the Police Act, the police ought to be a neutral party. I grant them that. But the neutrality of the police will be questioned when the police as an institution now take on the responsibility of tendering a document that the law does not grant him the power to tender. That's the problem here. Nothing in our laws empower police, to tender that document in the state in which he tendered it before the tribunal in Port Harcourt. And I still say that it's simple. I'm appearing before you. We have original documents here. I come with the photocopy, certified by me, and it's your document, Amechi. It's your document. You gave me the duplicate copy. On a certain day, you asked me to produce the document.
Did INEC present his own result sheets before the tribunal?
INEC presented his own result sheet, and that is the argument not reflected in this judgment. I've read through the judgment. I'm at pain.
The places where elections the result according to the tribunal were not included. Did INEC also present those said results?
INEC presented those results.
Those results that were cancelled.
The results that were cancelled. Presented a document. The picture that emerged from the tribunal is this: in those election documents that were tendered by the police were only signed by party agents of the petitioner, party agents of the petitioner, while the results that were tendered by INEC were signed by party agents of the petitioner and the respondents. So that's why I'm at pain to understanding the basis in which the tribunal came to the conclusion that we believe or we prefer the evidence adduced by the petitioner, and we do not prefer. There's a language somewhere in page 15 that we do not prefer the evidence presented, presented by the respondent. Here, it's on the basis of probability. The basis of probability, you're accepting or preferring must be dependent on the probability value of the evidence. And if INEC's evidence has greater probative value, and it's several also case law authority in our country that whatever result INEC present before the court or tribunal, the assumption or presumption in law is that that result is authentic and genuine until the authenticity of the document of the result, authenticity of the result is rebutted. In this case, two contradictory documents were produced by the first respondent, INEC, and by the petitioner. While INEC's document has party agents signing, the one presented by the petitioner has only the party agent. So it raises fundamental questions. And if you look at the table, I think page 17 of the judgment itself, if you look at the pattern of vote in Rivers Senatorial District, across the 7 local governments, except Eche that was not declared, INEC cancelled it. The result across the local government were competitive, separated by 1,000, 2,000, 3,000, 4,000 votes. The local government in context, Emoha and Ikwere, the margin, between the contesting politicians are in the region of 10, 15,000 plus.
And it made a lot of difference in the final.
And it made a lot of difference in the final.
At least the good thing is that this issue will get to the appeal court. It is a senatorial election case, and the appeal court is the final court of appeal. So when it gets to the appeal court, these issues will be tendered before the learned justices, and of course, justice will be served. Abdul Mahmood is President Public Interest Lawyers League, and he has been speaking on issues arising from the Rivers East senatorial election, whose result was contested in a tribunal in Abuja that oversaw, of course, elections from that part of the country. Thank you so much for joining me on the program today. Thanks for having me again. Thanks for being part of it also. My name is Amechi Anakpo. We'll see you on Monday. Have a good weekend.